here to talk with some of the
Meeting of the House Labor and Workplace Standards Committee will come to order for public hearing. If we get some time, we may pick off a few bills for executive session, potentially 1155 and for sure 1490. So we're going to be prepared for that. With that, we'll start with House Bill 1395, and I see Representative Pelliciotti is here. If you'd like to come forward and be prepared, we'll have a staff briefing on 1395.
Good morning, Mr. Chair and members of the committee. House Bill 1395 deals with wages owed to workers and benefit payments owed to third party on behalf of workers on private construction projects. Current law provides remedies to workers who are owed wages through the Wage Payment Act. This act provides an administrative remedy under which a worker files a complaint with L&I, and L&I must investigate, and if it finds a violation, it may order the employer to pay the wages as well as interest. A worker may decide not to pursue that administrative action and instead pursue a private cause of action. This bill makes what is called a direct contractor liable for wages and also for the benefit payments. The direct contractor is the entity that has a direct contractual relationship with the owner, for example, the prime. And it sets forth who can enforce this liability and how. First, L&I could enforce the wage and interest liability through the Wage Payment Act, or it may also file a civil cause of action against the direct contractor. A third party that's owed benefit payments may sue a direct contractor for these payments. Also, a joint labor management cooperation committee, which is a committee that's recognized by federal law, or an interested party may sue a direct contractor or a subcontractor at any tier for unpaid wages, including the wages owed by the direct contractor under this new liability that's created. These entities must first, though, provide 30 days notice to the direct contractor and the subcontractor. For these individuals, if they prevail, they are entitled to attorney's fees, costs, and expert fees. There's also a provision saying that if the direct contractor requests, the subcontractor must provide payroll records. The bill specifies what these payroll records are and provides that a direct contractor may withhold sums owed to a subcontractor if they don't provide this information within 10 days. A fiscal note is pending, and I'd be happy to try to answer questions.
Are there any questions? Hearing none, Representative Pelliciotti, thanks for being here this morning.
All right. Well, thank you, Mr. Chair. Thank you to the committee for hearing this bill. Mike Pelliciotti from the 30th Legislative District. And, you know, we've just all seen how things have played out recently with the federal shutdown and the issues of people not getting paychecks that they were expecting to get. And there was a recent study, I think it was updated just a few months ago, that indicated that half of Americans could not afford an unexpected obligation of $400 in a given month. And when someone doesn't receive their paycheck, it's that much more serious in terms of the impact that it can have on their life. And, you know, I heard the story of a constituent who was recently a victim of wage theft. And, you know, in looking into this issue more, I started to realize that obviously the way the laws are currently set up and have been set up for a long time, it allows a small minority of dishonest direct contractors to essentially not be responsible, or I should say a small amount of dishonest subcontractors to make it so that a person who works an honest day's work is entitled to a certain payment to not receive that payment and have no real recourse. The system is set up right now in a way in which that person can't go anywhere to get the payment that they are entitled to receive. And what this bill does is it seeks to create some fairness, because it takes the burden off the individual who is not being paid. That individual person providing, in this case, carpenter services, and makes it so that the entity, the general contractor who actually has received the benefit of those services, and makes it so that individual is responsible for making the worker whole. And, you know, it's one of those situations where, you know, we have a legal system where there's a real challenge related to how else to do enforcement. You know, there are reasons for a long time why a system has been set up with independent contractors in this way. But we've reached a point where so much of the burden is placed on the individual worker in terms of just trying to be made whole when they're just doing their job. And this tries to find a way to make it so that a worker can go to work, make sure they're paid for the work that's done. And it's modeled after a California law that was implemented a few years ago that really has shown, at least what I've been able to read up on, very positive enforcement. It's encouraged the rooting out of those bad actors, subcontractors who have repeatedly committed wage theft violations. It's very much starting to discourage associations with those subcontractors who have a long history of these situations. And I really hope it will allow for rooting out of those dishonest subcontractors and make sure that those who are just putting an honest day's work are not the ones left holding the bag when they're not being paid.
Thank you very much. Any questions for Representative Pelliciotti? Hearing none, thank you. And we're going to skip ahead and then come back to testimony to House Bill 1556. And Representative Mead, if you'd like to come forward.
Thank you, Mr. Chair, members of the committee. For the record, Trudis Tango, staff to the committee, briefing on House Bill 1556. House Bill 1556 creates a grant program called the Opportunities for Employment in Hospitality Grant Program. The purpose of the program is to increase the number of people from targeted populations employed in the hospitality industry. Targeted populations are defined in the bill as persons who are experiencing homelessness, re-entering the workforce after an extended absence, veterans, spouses of veterans, or persons seeking employment in hospitality. An entity or person awarded the grant must host a minimum of 4 hiring events, at least 3 in Western Washington and 1 in Eastern Washington, must also offer the targeted population post-employment services and training, must coordinate with the Department of Social and Health Services to connect participants with wraparound services, must create an annual report to the legislature with data showing the number of individuals being served and the number who obtained employment, and must participate in other activities to support the purpose of the grant. The Employment Security Department must administer the grant, including performing any audits necessary to ensure grant funds are used solely to support the objective of the grant. A portion of the grant must be used to cover the costs incurred by the Employment Security Department and DSHS for implementation. The bill also contains a null and void clause. I'd be happy to answer any questions.
Are there any questions for staff? Hearing none, we'll go to Representative Mead. Thanks for being here.
Thank you, Chair Sells and members of the committee, and thank you to Trudis for the briefing. For the record, my name is Jared Mead, State Representative in the 44th. In a beautiful state like Washington, with the recreational opportunities that we have and the restaurants and the hotels, it's especially important that we have a workforce, a qualified workforce, a pipeline of hospitality employees, both for our tourists but also for our community members here in Washington. What this bill would do is create an Opportunities for Employment in Hospitalities grant, which supports a public-private partnership between the industry and ESD and DSHS to help connect job seekers with available positions in the industry. And the reason this partnership is key is because of the emphasis that ESD and DSHS put on seeking homeless folks and formerly incarcerated people or people just trying to re-enter the workforce when they're recruiting. And this bill is really a win-win for that reason. We're helping boost Washington's economy with the vital industry of hospitality, but also help connect people who are most in need of finding employment with those opportunities. And with that, I know we have some folks here to testify later, and so I'll leave it at that. I'd be happy to answer any questions.
Are there any questions for the prime sponsor? Hearing none, thank you very much, and we'll return to testimony. On House Bill 1395, I'll call forward Evelyn Shapiro O'Connor, Corey Elliott, Miguel Perry, and Josh Swanson. We're doing the 3-minute rule, so be prepared. Please proceed.
Good morning, Chair Sells and members of the committee. For the record, my name is Evelyn Shapiro O'Connor, and I'm the Principal Officer for the Pacific Northwest Regional Council of Carpenters. I represent over 24,000 carpenters throughout the 6 states in the Pacific Northwest, and I'm a carpenter myself. I came out of the craft, started 19 years ago as an apprentice carpenter, and actually testified here before this legislature on some bills as an apprentice, so I'm very glad to be with you here today. This issue is very dear to me and something I'm very passionate about. When I came out of the field from working with my tools, I started working for the union, and I had never been on a non-union construction site. You know, I was an apprentice, and my experience was experiencing safety and experiencing, you know, a productive, safe, healthy workforce. And I never had to deal with things like begging for my pay or, you know, begging for an advance so that I could pay my rent. That just wasn't a reality for me. So I was really very shocked when I went onto some sites that really were criminal. And, you know, in my mind and in our organization's mind, it's not a matter of union or non-union in those moments. It's really, are we doing things fairly, or are we, you know, are we really acting as criminals here? I observed things that really blew my mind. I saw workers that were asking for their pay and were being shown a gun in response and saying, you know, if you're gonna ask for your pay that you're owed, then, you know, you'll just experience this threat. Workers have completed a job and were sent to ICE, you know, were sent to immigration rather than getting paid, of course, after the job was completed, not before. Utilizing ICE, you know, as a system really just to create free labor in our country.
Thank you very much.
Good morning, Chair Sells and members of the committee. For the record, my name is Corey Elliott, Government Relations and Washington State Lobbyist for the Pacific Northwest Regional Council of Carpenters, representing 16,000 members in the state of Washington. As you just heard from Evelyn, there is a growing epidemic in the construction industry. Wage theft is becoming normal practice throughout the nation and right here in Washington State. House Bill 1395 aims to combat the growing problem of wage and benefit theft in the private construction industry by holding general contractors responsible for the unpaid wages and benefits of the subcontractors that they select. House Bill 1395 would do the following. It would allow the Department of Labor and Industries to enforce against direct contractor unpaid wages owed by the subcontractor, allow a third party owed fringe and other benefit payments or contributions by a subcontractor to bring a civil suit against the general contractor. And third, it would allow an interested party to bring a civil action against the direct contractor or subcontractor for wages owed. The law would encourage self-policing in our industry because if a direct contractor risks liability for back wages and benefit payments, they would have to take into account the likelihood that a subcontractor would not pay their workers properly. This helps the workers have more security by knowing that business decisions take into account a potential employer history of following wage and hour laws. It helps businesses that follow the rules compete because general contractors will have to think twice before going with a cheating subcontractor who bids at a much lower rate. Finally, it helps the state and local governments that lose our revenue when workers are not paid what they are owed. And just, you know, we've been working with L&I. They've identified a couple of technical issues with the language that we're working to resolve with them. And, you know, as the carpenters, we strongly urge this body to pass this, this House Bill 1395 out of committee with a due pass recommendation.
Any questions? Representative Hoff.
Yes, thank you, Mr. Chairman. I'm struck with, by the way, if you perform the required labor, you should be paid. Mm-hmm. There's no question about that. So I'm struck, ma'am, with the challenges you faced, and then did you indeed call the Department of Labor and Industry and say, hey, there's something wrong here? Again, there should be some action that's already in place for those infractions.
Yeah, absolutely. I actually ran a department that focused exclusively on processing civil and criminal wage claims for the last 4 years throughout our 6 states. And I've worked with LNI. I've had cases with the Seattle Police Department going undercover, actually training them in my garage to be undercover drywall labor brokers. I've worked with the Oregon Attorney General's office on civil or on criminal cases as well. And I will tell you that for all of the processes that exist, the processes have to be individually input, individually followed, and it is, I would say it's probably the job of 100 times what the agency staff have currently. And, we're all sympathetic to, budgets and staffing issues, of course, but there just simply isn't enough infrastructure to really enforce the laws appropriately.
Representative Hoff.
So, thank you, sir. And with that said, what would this bill, or how would this bill cut down on that enforcement load? I mean, just simply passing the liability on, or?
So this would give the unpaid workers an additional opportunity to collect their wages. They can use a interested third party, or a nationally recognized labor management organization to go directly after the general contractor for with a lawsuit, basically. This process will be a lot quicker than sometimes the LNI process is, and it will be a quicker resolvement of those unpaid wages.
And I will say that this is also a favorable resolution in some ways to general contractors. I remember a time as an early organizer for the union when I was out on a job site, and I met a contractor who had said, "Hey, you're with the union?" And this is a non-union contractor. And I said, "Yes, I am." And I recognized his name. And the reason I recognized his name is because I had filed a lien against one of his former projects. And, he didn't realize who I was, but he said, "Hey, could you please help me out? Could you look at my subcontractors and make sure they're okay?" He said, "I had a really terrible experience in a previous project where I had to pay twice. I paid the subcontractor first, and then I had to pay again, later on in an advanced lien process." This would clean up that process. It would introduce bonding so that they wouldn't actually have to end up paying twice, but that they still would be ultimately responsible for who they choose to have on their jobs.
Thank you very much. Any further questions? Hearing none, Jerry Vanderwood, Rick Helm, and Tom Kwesiak. And then that'll be followed by Miguel Perry and Josh Swanson. Mr. Vanderwood.
Mr. Chairman, members of the committee, I'm Jerry Vanderwood with Associated General Contractors. While we appreciate the interest of the sponsors to ensure that workers are paid, I do have to express our concerns about this particular piece of legislation. To be clear, AGC is opposed to wage theft. Not only is it wrong, it creates a competitive disadvantage for contractors who are playing by the rules, doing the right thing, and paying their employees what they are owed. Clearly, the employers who are cheating their employees of their wages are currently breaking the law. But this bill might even make it easier for culpable employers to play loose with the law if they know somebody else will pay for their mistakes. One of the purposes cited in this bill is to encourage self-policing in the construction industry. In our view, this bill does not encourage self-policing at all. It simply requires one business to police and be responsible for the actions of another business. Nevertheless, we're willing to work on this, and some of the questions we'd like to work on are: can we avoid scenarios where a general contractor pays twice? That is, the general pays the sub in full and then later is informed the sub had unpaid wages that the general pays again. And can we think about the timing of this process? How can all parties work to ensure that unpaid wage scenarios are discovered more quickly before, hopefully, the culpable entity gets away? Information from the benefit trusts, which have both contractor and labor trustees, is often particularly slow in coming. What role might LNI play? The bill amends RCW 4948. That chapter lays out the process LNI takes with regard to wage complaints. For example, it can look at situations that occurred up to 3 years ago. It has 60 days to issue an assessment. There's an appeals process, etc. Does that process play completely out before turning to the general contractor, or is that elsewhere in the process? In other words, how hard does L&I go after the culpable sub before the general's liability takes over? Another element of our concern is the fact that this bill was introduced last week and already has a hearing this week. We've had very little time to digest the ramifications of this bill. A stakeholdering process seems appropriate for such a complex issue that involves so many parties to a construction project, and one that would so dramatically change business relationships in construction. AGC looks forward to participating in such a process. Thank you very much.
Mr. Kwisiak.
Thank you, Mr. Chair. I just want to briefly introduce, for the record, BIW's 2019 President Rick Yelm here to testify. Rick's a general contractor out of Lakewood, Washington, and I'm going to let him testify, and then after he goes, if it's okay, I'd like to make some comments as well. Thank you.
Again, my name is Rick Yelm. I'm a general contractor out of Lakewood. A small company, we generally do remodeling. I currently have 10 employees in the field, 2 of the office staff, and a designer. We as a company understand what goes on, but due to state requirements, I have to have subcontractors. I have to have an electrician who's licensed. I can't do it myself. I have to have a plumber who's licensed. Can't do it myself. Common sense tells me that I'm going to hire a concrete guy and a drywall guy and a roofer. I'm not going to do those things myself or in-house. Part of his insurance liability being driven by the insurance industry. There are things I can and cannot do as a remodeling contractor. One thing we do is all of our employees, we treat them well. We treat our subcontractors as if they're family. But because of the complex nature of the remodels that we do, generally a whole house, it's not uncommon in a major project to have up to 75 subcontractors on that house. And if I'm required to babysit every single subcontractor and then his employees, and the fact is I know them all well. I know every single subcontractor on that job and his employees. But I can't police what they do, yet I trust them. And I've never, ever, and because I know the employees, if the employee is having a problem of the subcontractor, he's going to come talk to me. We basically know what's going on, but I don't have the staff or the money to hire more staff to go after every subcontractor and to say, I need a copy of your payroll. I need a copy of all your benefits. I need to see what you're doing for every one of your employees. On the flip side, my friends in the home building industry, many of them have one employee who's in the field and they're 100% subcontractor. So I can't imagine what they would have to do to be able to track every single one of this. Now, people who are big companies, I understand they have a bigger staff, but we are small companies. We are the entrepreneurs of this state. And I'm concerned that this bill would somewhat kill that entrepreneurial spirit, knowing that the burden that you would have to do, that if you want to be a general contractor or remodeler, you've got to track every single subcontractor, what he does, and every time you write him a check, which, by the way, I pay my subcontractors every 15 days. So that they don't have to worry. That way they have the money to pay their employees. They don't have to worry about taking money from the next job to pay this job. Everybody gets paid. And we teach that throughout Pierce County. I actually oppose this bill. And I see some good, but I see a lot of bad and how it's going to be really onerous. And there's a way to fix it. Just bring us to the table.
Thank you very much. Mr. Kwisiak, did you want to add anything to that? Or?
Yes, Mr. Chair, thank you. Yeah, I just want to, again, reiterate that this is just going to require contractors, remodelers, and maybe even homeowners, the way I read the bill, to become wage and hour experts / enforcement officers. I think we already have staff at L&I that gets paid to do that. I kind of heard the comment that what about the budget and staffing issues? Well, what about the budget and staffing issues of people like Mr. Yelm here? They can't afford to hire somebody to track down 75 subcontractors, hundreds if not thousands of employees, and make sure that they're paying not only payroll, health insurance benefits, education benefits that some employers pay, et cetera, et cetera, et cetera. So I think there already is recourse in the system, and that's the L&I Wage and Benefit Office. If they're not doing their job, then maybe we need to have LNI come up here and explain that rather than putting this on the employers. Thank you.
Thank you very much. Any further questions? Hearing none, Mr. Perry and Mr. Swanson. Thank you for being here, gentlemen.
Good morning, Chair Sells and members of the committee. My name is Miguel Perry with the Northwest Carpenters, and I'm here today in support of House Bill 1395 because wage and benefit theft is a serious problem for workers in construction industry that needs to be stopped. Crooked contractors commit wage and benefit theft to gain an unfair cost advantage over law-abiding competitors to win projects and make profits. I take this bill very seriously because, like many construction workers, I myself am a victim of wage theft. And even though it happened long ago, it is still fresh in my mind. I clearly remember after working for a few weeks for an unscrupulous contractors, I was an unscrupulous contractor. I was not paid because he claimed the general contractor had not paid him. However, he promised as soon as he had the money in his bank account, he would pay me. But he never did. I was too young and I didn't know what to do, so I ignored it and moved on to the next job. Wage theft to workers happens every day. As an organizer for the Pacific Northwest Regional Council of Carpenters, I come into contact with victims of wage theft. It's hard to believe, but some workers don't even get paid. A few years ago, I stopped at a job site here in Skagit County where Hispanic workers were hanging drywall. I had been there a month before and noticed a brand new crew on site. When I asked about the old crew, I was told that they left because they had not been paid for over a month. When I asked the new crew why they were working for this contractor when they knew that they may not be paid, they responded in Spanish, "Siempre hay esperanza." Translated to English, there's always hope. I'm here today because there is little they can do about it but hope. You, on the other hand, can make a difference. Today I was planning to be here with Luis Llamas and his brother Sergio Llamas. They told me they were going to be here, but they chose not to in the last minute, and I understand why. They decided not to come because, like many of the Latino workforce that works in construction, they're undocumented workers, and they fear the consequences that come with it. Luis and Llamas were hired by coyotes, the Spanish word for labor brokers. These coyotes came from Nevada. Excel Pacific, the general contractor for the build-up for apartment units in Linwood on 196, hired a wood frame subcontractor from Vancouver, Canada, by the name of Millframe LLC. Millframe hired these labor brokers to bring in Latino crews from all over the country to work on their job site. The arrangement was for Millframe to pay the labor brokers with checks, and they would drive to California to cash the checks to avoid the paper trail. Then the labor brokers would pay the workers cash under the table. When Luis and Sergio Llamas...
I'm going to have to ask you to summarize, Miguel.
Okay.
And turn the rest of, if you've got it all written out, give it to the OPR staff for the record.
Okay. Wage theft has become a business model for unscrupulous crooked contractors who use labor brokers to shield themselves from the liability. And the reason they do it is because they know they can get away with it. Wage theft not only affects cheated workers, it also affects cheated law-abiding contractors.
Thank you very much.
Thank you, Chairman Sells, members of the committee. My name is Josh Swanson with the
You may want to stay here because they'll have questions. Thanks.
With the operating engineers. We represent about just under 14,000 members in Alaska, Washington, and Idaho. I'm here today speaking on behalf or in support of House Bill 1395. Want to say that I obviously support the testimony from the other proponents of this bill, and I'm going to get into a few of the finer points that I think will aid in your deliberation. Unlike public work, private work does not have a performance bond or a retainage for which workers are able to seek or recoup wage recovery. Also, for private work, the contractor bond is, quite frankly, grossly inadequate in the amount of $6,000 for this wage recovery in situations where let's say a subcontractor goes out of business, that may be the only pool of money that a worker can seek to recover their lost wages. And while they're seeking that, there are others like taxing entities and suppliers that are also vying for those limited dollars and resources. Also, I want to point out that the prime contractor has all the leverage in the subcontractor selection and administration. They also have the privity of contract with that subcontractor and have, quite frankly, the leverage to exercise against that subcontractor if, in fact, there is a problem in the payment of the workers. Also, there is no, like public work, there is no responsible bidder criteria, so the primary motivating factor in selecting a subcontractor is generally price. And as the old adage goes, you choose the low price option, don't be surprised at what you get. And unfortunately, in this situation, it's the workers that are going to be the ones that are harmed by not being able to recoup their wages and benefits. Also, the law does not currently have for private works prompt pay provisions. That don't, so subcontractors may be put in a position where they are not paid and not able to pay their workers because they are waiting for payment from the general contractor based on stipulations and other criteria that the general contractor needs before making payment. Quite frankly, this bill provides necessary and comparable protections to what already exists in the public works laws that ensure workers are able to recoup their wages and benefits. We also think that this bill will change the behavior from low price to more responsible contractor selection, and that prime contractors will adjust by establishing criteria and possible contractual provisions to ensure that worker wages and benefits are paid. The last thing we want to see is a worker that doesn't get paid for no fault of their own. I wanted to point out a couple of things that I heard in the prior panel's testimony. One, Mr. Young, it sounds like he has already done some of the things that the bill is attempting to get to by selecting contractors that he knows and has dealt with and have a track record with to ensure that they're not going to be put in a situation where their workers are going to have to obviously seek recoupment through the prime contractor. Also, he mentioned that he pays within 15 days. So that prompt pay issue that I mentioned doesn't sound like that would be is a problem for him. The bill doesn't address that currently, but it's certainly something for consideration. So with that, I urge your support, and thank you very much.
Are there any questions for the two panel members? I know we do have a question for the department, and Tammy Fellon's here. Representative Mossbrucker. Come forward.
Thank you, Mr. Chair. And maybe staff may be able to answer as well. So when we have a worker who doesn't get his paycheck, what are the next 3 steps, and what are the sanctions to the employer currently?
Is there someone else here who can do that, or?
Well, Mr. Chair, I could respond briefly from the department and would invite staff to supplement my answer. When we get a wage complaint from a worker, the law requires that we investigate, and so we will investigate when we get a complaint. We do have authority to, and our data will show that the majority of those wage complaints, when we conduct an investigation, identify that wages are owed, the majority of the wages are paid at that point, where we don't have to take formal action against an employer. That's not just specific to construction, it's all employers. So, but we do have the ability to issue what we call a notice of violation, and then we can assess interest as well. There are some penalty provisions that could be applied. Workers also have the ability to sort of end the administrative remedy and take a civil action through court. What we find is often, while the law will tell an employer they can't retaliate against a worker in that situation, there's no remedy, there's no penalty for the employer who fires a worker in that situation. There's nothing the department can do in that situation. So we do have workers who are concerned about filing a wage complaint because there's really, on the other end, little or no protection if the employer retaliates against them in that situation. So there are absolutely some limits on the department's authority to pursue these. We prefer, of course, when a worker is paid what they're owed, and when we can settle that voluntarily with the employer.
Yes.
Thank you, Mr. Chair. So how long from the time that the worker reports to you that they didn't receive their check do you begin the investigation?
We have a 60-day period for investigations unless good cause, so it can be a complicated investigation. And the majority of those investigations are resolved within 60 days.
Thank you very much. Any further questions? Hearing none, that closes the hearing on House Bill 1395, and we're going to move to House Bill 1533. Staff report.
Thank you, Mr. Chair. For the record, again, Trudis Tango, staff to the committee. House Bill 1533 deals with domestic violence. The bill requires the Employment Security Department to create an employment poster regarding domestic violence. The department must make the poster available on its website and in other formats. The poster must include a space in which an employer must provide the names of community resources on the poster regarding domestic violence. The employer must post the poster in a conspicuous place where other required workplace posters are posted. The bill does not create any liability for any person or entity for any acts or omissions. I'd be happy to answer any questions.
Are there any questions? Representative Mossbrucker.
Thank you, Mr. Chair. I appreciate you bringing this bill forward, and especially this quickly so I can go on to the next meeting. So what I've learned, and I spent a large amount of time over the interim touring through the district and talking to domestic violence victims, and what I've learned is that the one place that many domestic violence victims are able to go away from the perpetrator is work, and primarily that's for the ability to pay rent or a house payment. So we've had horrific incidents in the Yakima area, which is in my district. We've had a woman who was beat to death with a baseball bat, and we had one that was recently burned this summer and put in a barbecue pit. And the one place that they can go and possibly get help away from that perpetrator, we think, is probably work, and by testimony of many victims. So what we're hoping to do is take an action item rather than, we do have a study task force bill, which hopefully will shed some more light on solutions to this horrific problem. 1 in 3 women and men, according to the statistics, is affected by domestic violence of an intimate partner. And we had over 54,000 calls reported for domestic violence in 2017, just in the state of Washington. So I feel like this is something that we can't just keep talking about. It's a difficult topic, but we need to have an action item. So we simply ask, as you heard by the great briefing from our staff, that we ask that businesses, all 700 in the state of Washington, simply hang up a poster, a small poster created by ESD that would have information on the top to a hotline of who to call, and then the bottom part would be blank. And in my particular area, we have a program for peaceful living. The Yakima area has a YWCA, and you'd simply just put a phone number. So hopefully the employee will walk past this area we have in all of our businesses mandated anyway, where workers' rights and minimum wage posters are, and maybe notice that there was a number to call rather than going home and being unsafe. So I commend the bill for review.
Are there any questions? Hearing none, I'll call for Nick Struley and Bob Battles. Everybody's pro. Not pro domestic violence, but pro this particular.
Pro on the bill, the wonderful bill, yeah. Thank you, Chair Sells, members of the committee. For the record, Nick Struley, Legislative Director with the Employment Security Department. As you mentioned, we're signed in pro on this bill, and I think staff did a great job, and it was wonderful to hear your comments, Representative Mossbrucker, and we really appreciate the partnership and dialogue as you were developing the bill. We think this is a wonderful opportunity for ESD to work closely with the employers across the state to make these resources available. And, you know, again, if it helps even just one person, right, that's enough. So we think this is a great step. We look forward to partnering with the stakeholders in developing the poster, and I'm happy to answer any questions.
Mr. Battles.
Bob Battles, Association Washington Business. Again, we want to, we're testifying as pro to this bill too. We appreciate that this is a huge issue that needs to be addressed, and we appreciate the creative kind of outside of the box trying to find a solution that's where there's can be so where people can find these protections. I will say one thing is that because it has an ability to put a phone number in there, and I want to make sure that employers, you know, that will do their best to find it, but since there's no guidance on what number to put there, if there is a number that they don't have there, I don't want to make sure we don't have some sort of liability on employers that they only put 3 numbers and there was a 4th number they could have called or something like that. I just,
I just don't know what kind of guidance we can give to employers maybe through this process. I don't think employers are going to be thinking about, what numbers should they put there. So that's sort of some guidance there that would be helpful. But again, we appreciate the opportunity to participate and help on this bill.
Representative Mossbrucker.
Thank you, Mr. Chair, and thank you for bringing that up. I think what we foresee, and again, Employment Security Department does an amazing job on posters. They did the SVET, and it's beautiful, and it's something that I know that they're going to follow through and do a great job on. But we've asked that survivors, also have a voice, and ESD has agreed to listen to what number you would need to call if there's not a local resource, which in some sadly in some areas there isn't. Then I just foresee a national hotline number. So that would give you a default, a 1-800 number. So thank you.
Well, if that can be included on the actual poster, that's fantastic.
Absolutely.
Thank you.
Yeah, absolutely. Thank you.
Thank you very much, and that ends the hearing on House Bill 1533. We'll move to House Bill 1445, the staff report.
House Bill 1445 deals with unemployment insurance and persons with responsibilities to care for a child or vulnerable adult. It's similar to a bill that you heard after cutoff last year. And first, just some quick reminders about eligibility for unemployment benefits. A claimant must have worked 680 hours in their base year, which is generally the first 4 of the last 5 quarters. And they have to have been separated for a reason that was not their fault, or they quit work for good cause. And they must also be ready, available, and actively seeking work. So the good cause quits are listed in statute, and they include, for example, that the separation was necessary because of the illness or disability of the claimant, or the illness, disability, or death of an immediate family member. There's certain prerequisites for this good cause quit. And to be available, a claimant must be ready, able, and willing to accept any suitable work. And generally, suitable work is employment in an occupation in keeping with the claimant's prior work experience, their education and training. There's some additional factors that are listed. And under ESD's rules, the claimant must be willing to work full-time, part-time, and accept temporary work during all of the usual hours and days of the week that is customary for the employee's occupation. There's a special provision for part-time workers. This is a worker who did not work more than 17 hours a week in any base year weeks and earned wages in at least 40 weeks. And for these workers, they do not have to be available for all of the full-time. They can apply for only part-time work. So what this bill does is it makes changes with respect to several of those provisions regarding eligibility. And first, regarding good cause quit, I mentioned the reason for the death, illness, and disability, and that's changed to add that, or if care for a child or vulnerable adult in the claimant's care is inaccessible. Also, the family member no longer needs to be an immediate family member. In current law, the claimant has to pursue all reasonable alternatives to try to keep their job. That's changed to they have to make reasonable efforts, including requesting changes in working conditions or work schedule, or seek a leave of absence. It would also add another good cause quit reason, and that would be that the work shifts change to make care for that child or vulnerable adult in the claimant's care inaccessible. And as you probably know, unemployment insurance is experience rated, and in this case, if the claimant quit for that reason about the availability of care, those benefits would only be charged to the separating employer. They wouldn't be charged to other employers. And then second, with respect to suitable work, the availability requirement is changed so that the claimant has to be available for at least as many hours per week as their typical work week hours. Also, in determining suitable work, the availability of caregiving for a child or vulnerable adult are factors. The bill would direct ESD to adopt rules to ensure that claimants remain attached to the labor force and also be available for scheduling that's reasonably available in their local labor market and occupation. The part-time provisions are deleted. There are a number of changes in the bill regarding cleaning up language, correcting double amendments, et cetera. A fiscal note is in process. I'd be happy to answer questions.
Are there any questions? Seeing none, Representative Gregerson.
Thank you, Mr. Chair and Ranking Member Mossberger, for hearing this bill today. And thank you, Joan, for the overview. For the record, I'm Mia Gregerson for the 33rd District, and I'm excited to really have this conversation again this year. We talked about it last year in a work session, as she mentioned. And since then, we've really worked hard on this legislation by reaching out to business. We actually had several conversations with ESD and Commissioner Levine, and of course stakeholders, to make sure that this legislation really got to the crux of the problem. And the problem is right now that so many women, especially, who are having to leave the workforce because they need to either care for their children due to high costs or unavailability for daycare, or care for their aging parents. My parents are baby boomers, and I can very much see that in my future. What happens is it's too hard for them to qualify for unemployment. We heard already today that so many Americans, Washingtonians, live paycheck to paycheck, and so this is really the difference between them being able to stay in their home, keeping our families together. This also talks to some of the complexity of our families, and making sure that those that are caring for each other aren't necessarily bloodline. And with that, you'll hear more stories today, and you'll hear why really being ready, willing, and able 24/7 is not going to work for so many people. Probably those of us sitting on this dais, it would not work. So thank you again.
Thank you very much. Any questions? I'll call forward Maggie Humphreys, Ann Paxton, and John Turpak.
Morning, Chairman Sells and the committee. My name is John Turpak. I work with the Unemployment Law Project. Unemployment Law Project has been a nonprofit organization for over 30 years, advising and representing unemployed workers in Washington State who are having problems with their unemployment claims. And this issue of problem of caregivers and child care, caring for vulnerable adults, is an issue we've seen for many years. And it's an issue that affects men and women of all economic backgrounds and from all parts of our state. I want to give a few examples we've seen. There was a woman from Kent, Washington, who told Employment Security that she could not take a job after 6 o'clock because her child care closed at that time. And Employment Security, due to the labor market statistics, said that she should be able to work until 7. And she was denied unemployment, and that was upheld by the hearing judge. There was a woman who was a Somali immigrant with 2 young children who worked jobs in mornings and afternoons and early evenings. She lost her job, and when she told Employment Security she could not take a job after 8 or 9 o'clock at night, she was denied benefits. And we even took that case to the Court of Appeals, and that the Court of Appeals, while expressing regret, and said that there might be problems with the law, but that the law as written had to be upheld. We've seen this affect men as well as women. A man from South King County had sole custody of his 8-year-old son, and he had worked a day shift for many, many years. And there were some family issues that made it really impossible for him to work at night, and the employer unfortunately had to shift his shift to the evening and night, and he could not take that. So he was denied unemployment because he quit, but also because he was not able to work 24/7, and he was in a 24/7 type of profession. Well, last year you heard from Kelly Sennett from Maple Valley, who took a job but then was told that she had to start at 5 o'clock.
I'm going to have to ask you to summarize, please.
Yes. And you heard from Jana Wolf, a mother from Spokane who had 2 foster children that needed care so that she could only work part-time. She was denied.
Thank you very much.
Thank you.
My name is Ann Paxton. I'm a staff attorney with the Unemployment Law Project. I work with John. I'd like to ask the committee's permission. One of our recent claimants prepared a brief personal statement. If I could have the committee's permission to read it.
How long is it?
It's 2 minutes. It's under 3 minutes.
Okay.
Thank you. This is from Margaret Bowen, who is a claimant that is a client of the Unemployment Law Project. She says, I live in Goldendale, Washington, in Klickitat County, and I am the mother of 3 children. I'm speaking to the committee today to describe my situation and how it led to a denial of unemployment benefits. These were benefits that would have partially replaced my wages while I looked for a job in my field. I worked for several years as a pharmacy technician on a daytime shift. When that job ended, I applied for unemployment benefits and was approved. Shortly afterwards, I took a job packing and labeling shipments in a warehouse. The first day I started work at 6 a.m. and the shift was not finished until 6:30 p.m. The second day I talked with a supervisor who said this would not happen every day and would try to get me scheduled for 8 hours a day. But I continued to have to work long hours all week, 11 hours on Tuesday, 10 on Wednesday, 8.7 hours on Thursday. This meant I was unable to care for my children in the evening because my husband has an on-call job. There's almost no child care available in my town. On Friday, my supervisor told me he could not get the 8-hour schedule approved, and I learned that these lengthy shifts were typical with this employer. I quit the job. Then I was notified that the Employment Security Department denied my unemployment benefits on grounds that I had voluntarily quit the job without good cause. The Employment Security Department classifies warehouse work, along with many other occupations, as a job with customary hours of 24/7. That means that under current law, you must be available for any work shift your employer requires. The denial of my benefits was just one of many denials that occur each year because of outdated laws that fail to take reasonable family needs into account. Most people who are unemployed want to return to the workforce and contribute their skills in a meaningful way. If work shifts make it impossible for them to provide child care or necessary care for a vulnerable adult in their family, the unemployment benefits program should not force them to accept that job. We need to stop preventing workers and families from receiving unemployment benefits when they have reasonable restrictions on their hours for family caregiving needs.
Thank you.
Thank you.
Good morning, members of the committee. Thank you so much for hearing this important bill today. My name is Maggie Humphreys. I'm representing Moms Rising. We're a grassroots organization with members all across the state. And as you'll see from the petition signatures being shared with you by staff right now, our members are very excited and proud to be here in strong support of House Bill 1445 to modernize our state's unemployment insurance laws. Put simply, Washington's current unemployment insurance laws fall short of reflecting the caregiving needs that many working people take on in their families, nor do they set reasonable standards for working parents struggling to find childcare. This is an important opportunity to make our unemployment insurance laws work for today's modern families. I'd like to share a couple more stories from caregivers in Washington who were unable to collect unemployment, specifically moms. Before starting maternity leave, one woman discussed with her supervisor, telling him that after the baby was born, she would no longer be able to work late on Tuesdays, nor could she work on Fridays. She had never worked on Fridays before. While she was about to return from leave, her supervisor emailed her a new schedule, Monday through Friday from 1 p.m. to 7 p.m. She was given 1 week to let them know if this could work. She tried to find a new childcare arrangement in that short amount of time and, not surprisingly, was unable to. The supervisor refused to negotiate. She had to quit and was denied benefits. Another mom was receiving benefits. She was offered a position as a dental assistant, as a dental hygienist, dental assistant, that required her to work on Saturdays. Dental assistants rarely work on Saturdays, and so she thought she could find another position that had more traditional hours and allowed her to care for her child over the weekend. When she turned down the job, however, ESD denied her benefits, noting that customary hours for dental assistants are 24 hours a day, 7 days a week. Put simply, these laws are not working for today's working families. Unemployment insurance benefits are something that a lot of us don't think about until we need them most. Just 10 years ago, our nation and our state fell into one of the worst economic disasters in this country's history, and unemployment was a vital program for families when they needed it. Today, we have an opportunity to make our laws work for today's working families before another recession hits us around the corner. Thank you again for working on this important bill, and thank you for all that you're doing for working families.
Are there any questions? Hearing none, thank you very much for coming. I'll call Bruce Beckett and Bob Battles forward. You're busy today.
All week.
Thank you, Mr. Chairman, members of the committee. I'm Bruce Beckett on behalf of the Washington Retail Association, representing thousands of retailers in every community across the state. I'm going to go back into a little bit of history here that I have on this issue. About 10 years ago, and some of you on the committee may remember this, we culminated about a 4 or 5 year effort with the legislature and a number of appointed task forces in which I had the privilege or perhaps the penalty of being appointed to during those periods to analyze and revamp Washington's unemployment insurance system to ensure that benefits are paid to eligible workers, to equitably distribute the cost for the system across employers, to equitably define and distribute the costs that are not charged to an employer called socialized costs, and to eliminate the wild swings in unemployment insurance taxes in the trust fund situation. And that work paid off. During the Great Recession, I believe Washington State was the only state, Mr. Chairman, wasn't it? Or one of 2 states that did not remain solvent. The Unemployment Insurance Trust Fund remained solvent, didn't have to borrow from the federal government, and indeed increased the benefit payments to unemployed workers during that period of time. So let's not forget that history. This bill does add an entirely new and unknown number of claimants potentially to the system. They're eligible, and as I read the bill, if the employer cannot accommodate the employee's request for a different work schedule or leave of absence. So the small businesses out there with small staffing are going to be the most vulnerable because they're going to end up having to pay for these changes in benefits in particular. I have a couple of ideas, and Representative Gregerson, maybe there's some ideas here. I'm not sure that this is the role of the Unemployment Insurance Trust Fund. That's kind of the crux of the problem. And I don't know the overlap with the Paid Family Medical Leave Program. Perhaps Bob does. But I think that that's kind of an interesting question about the role of the trust fund in this type of situation. And secondly, it used to be after we did that 4 to 5 years worth of work, there was a group called the Unemployment Insurance Advisory Committee that used to meet 2 to 3 times a year and focus on the metrics of what's happening in the Unemployment Insurance Trust Fund, what's happening to the type of benefits that are going on, what's happening, and it was a business and labor group with employment security. And we would talk about different ideas for the unemployment insurance system, and we wouldn't necessarily always be in agreement, but we're all working off the same facts and data. And perhaps if we're going to begin to enter into annual debates over the unemployment insurance system, maybe we ought to restore that process. So thank you, Mr. Chairman.
Thank you.
Bob Battles, Association of Washington Business, representing about 7,000 employers that represent or employ about 750,000 of the employees in the state of Washington. Although majority of our members, 60% at least, have 10 or fewer employees, so we've got small business and large business. We appreciate, I want to first of all thank Representative Gregerson for bringing this bill forward. We have had the opportunity to meet, and I appreciate the dialogue and the stakeholder, and I think that's very important. And I genuinely would like to try to support this bill, but at this point we must be opposed. I think Bruce brought up some of the things. We don't know what the cost is going to be to a system that hasn't had to absorb this. And I also will kind of say that when we read this bill, it has so many of the same elements as paid family and medical leave, which you know that I sat in that negotiation with several folks, and business worked hard to try to find a solution that worked for everybody that tried to balance that cost. And most of what we're talking about here is actually covered by that bill as well when it comes to the certain types of child care and the potential for there. So that while that bill has not kicked in benefits yet, because that starts in 2020, I think something like this, we don't know how this is going to interplay, but I think it's premature to look at this bill. I also want to kind of echo what Bruce said, that you know, this fund has been set up and was negotiated to try to avoid the pitfalls that many other funds throughout this country went through when there was a recession. And so we want to make sure that that doesn't happen. So I think my biggest concern is the cost. We don't know what that's going to be, and that this appears at least that to cover mostly what paid family and medical leave would always do, and that would actually pay a higher benefit than what the unemployment would pay. For I think the folks that we're most concerned about and the most vulnerable here, it would pay a much higher percentage of their salary during the time. So that's based on that. At this point, we must oppose. We look forward to continuing the discussion, though.
Thank you very much. Any questions? Seeing none, that closes the hearing on House Bill 1445, and we'll move to testimony on House Bill 1556. We've already had the briefing and the prime sponsor here. I'll call forward David Farrow and Jacques Farrell. Farrow and Farrell. And Nick Struley is available from the department.
Good morning, Mr. Chair and members of the committee. My name is Jackie Farrell, and I am the CEO and co-founder of Farrelli's Wood Fire Pizza. We were established in 1995. We have 10 stores across Western Washington right now. My family and I have been in the hospitality industry for 40 years, and we employ roughly 400 people right now, and during the busy season of summer, 500 people with our deck business. Hiring people with character versus specific skills has been our hiring practice for many, many years, and it has served us well. The first hiring we did in 1995 was in a dirt parking lot and very rudimentary. However, many of those hires are still with us today. We've had really great success with long-term employment. With the unemployment level so low right now, we do continue to have open positions available, and the hiring events that were put on through the Washington State Hospitality Association, that was just an absolutely amazing event. The events were unlike any other where the public and the private partnerships were created. We had candidates get placed into jobs, but they also provided services for the people seeking the jobs. And the job fairs, they help to break down the barriers that may prevent the job seekers having access. So basically, we hired a woman from one of these job fairs. We've hired many people from the job fairs, but one in particular speaks to me because our normal hiring platform is a digital platform. And the hiring fairs allow us access to folks that normally wouldn't be walking through our doors. And the diversity and the kaleidoscope of a restaurant family is what makes it so beautiful. And the hiring events have allowed us to have a greater diversity within our four walls. One woman in particular has now become Crew Member of the Year for two years in a row, mid-50s, somebody who normally wouldn't have walked through our doors, and she was able to have immediate partnership and access through the hiring event that we just wouldn't have had that not been available. I'm currently a board member of the Washington Hospitality Association, as well as a board member on the Education Foundation, and I'm a very strong supporter of Bill 1556. I'm excited about how this bill will allow partnerships to strengthen and also further connect employers and employees together, and I hope you will support this bill.
Mr. Farrell.
Thank you. Good morning, Mr. Chair and members of the committee. My name is David Farrow, and I'm the director of the Washington Hospitality Association Education Foundation. And also, my first job in this industry was as a dishwasher, and that was 31 years ago. Since then, hospitality has taken me to 153 different countries, and it's provided me 31 years of a fantastic career. That all started with a decision I made at 16 to go to a hiring event. So I completely support this bill, and so does our association and foundation. Over the last 2 years, we've offered more than 450 jobs to those seeking employment in our industry through these events. However, at the hiring events, we always have more jobs available than job seekers. This bill will help us make those connections and create what we call win-win opportunities. This was accomplished by a strategic public-private partnership with the Employment Security Department, and it was created by a pilot program funded by a federal grant. When the federal grant ran out last year, we were faced with a dilemma, and this dilemma was our needing to meet the workforce development needs of our industry and getting people to look at and be prepared for careers in the hospitality industry. I have personally, again and again, as someone who is hired in the hospitality industry as a full-service manager, I have seen the transformational power of a job. And jobs in the hospitality industry positively impact people's lives for the better, and I'm a living example of that. Like our industry, our hiring events offer jobs at every level of employment. Like I said, I started as a dishwasher, but now I wear a tie. From the first entry-level jobs to second chances at employment, like Jackie spoke about, and again, lifelong careers like my own. We recently had our Hill Climb Day, and the majority of our members, we asked for raised hands in attendance, got their start in the industry just like I did, as dishwashers, front desk clerks, and entry-level positions. Many of them also came to those jobs through hiring events like ours. So we need to make sure that we're supporting the hospitality owners and operators of tomorrow by presenting these job opportunities, especially to the populations that we've identified in this bill. So with the added layer of wraparound services offered by our community partners, we're not only able to have employers offer on-the-spot jobs like we did for Relly's, but we can also help break down a lot of the additional barriers to employment. So of course I'm here excitedly asking for your support for this bill, and we thank you for the hearing, and I hope to see each one of you at our hiring events in the future.
I'm not washing dishes anymore. Too old for that. Mr. Struley.
Thank you, Chair Sells, members of the committee. Nick Struley, Legislative Director with Employment Security. We're signed in other on House Bill 1556, and I just want to share with you some of the great work that we get to do at Employment Security. And really, a lot of that work is focused on helping people make their next career move. Our partners and staff in local WorkSource offices across the state help connect businesses looking for talent with job seekers looking to take the next step. We provide the statewide infrastructure for this work from bricks to clicks. We have more than 60 WorkSource offices, connection sites, affiliates across the state that provide in-person support to businesses and job seekers. We have a comprehensive website that provides job matching capability to scan our bank of resumes and provide employers with a list of qualified candidates. One of the most successful ways we've found to help rapidly employ job seekers is to partner with specific industries and associations to help make that connection and provide a targeted, sector-specific strategy that can scale at a regional and statewide level to connect employers in that sector with qualified candidates. This type of strategy has a proven track record of success, helping hundreds of businesses and thousands of job seekers every year all across the state. As anyone who's looked for work can tell you, it sometimes takes a village. And we believe that more partnerships, industries, and people working together can provide better outcomes for our customers and the job seekers around the state. We thank you for the opportunity to share a little bit about what we do at ESD and how some of these partnerships have played out, and I'm happy to answer any questions.
Are there any questions? Hearing none, thank you very much. And that closes the hearing on House Bill 1556. We'll move to staff report on House Bill 1594.
House Bill 1594 deals with who may do certain electrical work. And this committee has had multiple bills over the years dealing with electrical contractors and certified electricians. These are the contractors that a business or a homeowner hires to do work. And that work must be done by a certified electrician, and that work is under the National Electrical Code. And these laws, RCW 1928, are administered by LNI. And I don't normally refer to the chapter of the code, but it will be helpful for this bill. So there are also general exemptions from these laws. For example, telephone and TV wires are exempt, and utility poles are exempt, and line workers performing that work with respect to the utilities wiring. And this work is done not under the National Electrical Code, but a different code called the National Electrical Safety Code. And that applies for the installation, operation, and maintenance of electrical supplies. It sets up, electricity supplies, establishes safety standards for that. The NESC, the National Electrical Safety Code, also provides for the separation on those poles of the power supply space at the top of the pole for the distribution of the power, and the communication space at the bottom of the pole for cable, for example. And then there's a space in between 40 inches, which is called the communication worker safety space. In other words, it separates those two spaces. While the utility poles themselves are exempt from 1928, the work to install the equipment, the conduits, the wires, to bring power to customer-owned equipment that's going to be placed on those poles is not exempt. So the other element to this bill to be aware of is that apart from these electrical laws I've mentioned, the WISHA, the Washington Industrial Safety Act, applies to work done by the line workers of the utility, for example, and the certified electricians. There's two separate codes that apply to them. There's separate sets of rules, and the safety standards for the line workers, for example, include specific training requirements and also references the National Electrical Safety Code. So what this bill does is remove wires and equipment within that power supply space and also that safety space, the communication worker safety zone, on utility poles from the 1928 regulation. So effectively, it would be under the National Electrical Safety Code and those requirements regarding utilities. The bill also states that electric utility-owned equipment between a meter base and a meter would also be exempt from 1928.
Are there any questions for staff? Representative Chandler.
Thank you, Mr. Chair, and I appreciate the committee hearing this bill. And I thought the staff did an excellent job of explaining what is sometimes a very confusing issue, confusing to those of us that aren't particularly familiar with it. But I think that in the course of expanding broadband across the state, there's going to be a lot of installation on utility poles, and the people that will be doing that work want to have clarity about what their certification has to be and what the which code that they have to adhere to. And I thought that this would be a good opportunity to try and help find some clarity.
Are there any questions for the prime sponsor? Hearing none, Bill Clark, Dave Hansen, and Kathleen Collins, if they'd come forward. Thank you for being here.
You bet. Thank you for the hearing. Mr. Chair and committee members, I'm Bill Clark. I'm here for the Washington PUD Association here in support of the bill. With me is Dave Hansen, who for a number of years was with Benton PUD and now helps PUDs around the state on electrical safety issues. I'll just talk briefly on the bill. Dave's our expert on an issue that obviously you can tell from the staff report is a very technical issue. You know, in essence, technology changes over time. What we're trying to ensure is that the folks that do the work in the electrical supply space, which is at the top of the utility pole, do so as qualified electrical line workers. The space on the bottom of the pole is typically for telecom applications, but in 5G installations, much of that work is done at the top of the pole where only qualified line workers should be, and we're trying to clarify that point. Dave knows the details far better than I do, so I think I'll turn it over to him.
Yes, thank you. Kind of ironic, I wrote the first language exemption in 1973, and I'm back here now, 46 years later, modifying it. This bill is primarily brought up because of the 5G technology. It needs to be placed in the power zone, the power area, the upper distribution area of the power pole. Consequently, there's no way currently legally to do that without the pole being on the ground, installed by electricians, and then the utility comes in and puts the power in place, or they have to totally de-energize the facility, put grounds on it, have a safety watch, and then let the inside electrician get up there and do the work, which neither one of them are really feasible where they want these antennas on many different poles. This would exempt the line personnel, the utilities, from having to be able to allow them to use the NEC standards for installing a pole equipment in that area. Normally that is inside electrician work, the guys that wire your house, or communication workers. They're the ones that normally would do that work, but they are not allowed in the upper space on the power pole. They're not allowed where the power lines are, you know, the 7,000 volt lines or less. They're stuck down below. And WISHA will not allow them in that area. OSHA or National Electric Safety Code does not allow a communication worker in that space. So this is to clarify that issue. The other part of the bill is the technology issue also with the meter base. It just allows us to keep up with the industry standards. There's many different devices that go between the meter base and the meter, such as network gateway equipment, current limiting devices, and et cetera, and disconnects.
Thank you very much. Ms. Collins, you signed in other.
I did. Thank you, Chair Sells, members of the committee, Kathleen Collins with the Pacific Power, which is located in Representative Chandler's area. We are here as other, and obviously we do electrical work and have line workers, and safety is a paramount concern. We don't disagree with the intent of what they're trying to do. It makes perfect sense. The wording was, however, confusing to our folks, and so I'm not sure if it needs some clarification. The concern was that the communication workers would be allowed into the power supply area, which I know was not what was intended, and it was just the opposite. So we just wanted to state that I don't know if it's going to require a little tweaking with the words to be more clear about that point, but they asked that I come and articulate that today.
Thank you. Are there any questions? I guess I would ask you all to work together to see if that needs a little bit of clarification before we take action.
We'll do that.
Thank you very much. And that closes the hearing on House Bill 1594. We'll move to House Bill 1647.
Thank you, Mr. Chair, members of the committee. House Bill 1647 deals with marine pilots, or sometimes called harbor pilots. Just by way of brief background, the Board of Pilotage Commissioners recommends legislation and develops policies and rules for pilotage on the state's inland waters. They also enforce the Pilotage Act and administer testing, training, and licensing of marine pilots. The statute for rest breaks for marine pilots require that after completing an assignment that is 7 hours or longer in duration, a pilot or pilot trainee must receive a mandatory rest period of 7 hours. In addition, a pilot or pilot trainee must refuse an assignment if the pilot or trainee is physically or mentally fatigued, or if the pilot or trainee has a reasonable belief that the assignment cannot be carried out in a safe manner. If the pilot or trainee refused an assignment, the pilot or trainee must submit a written explanation to the board within 48 hours, and the board has authority to impose sanctions on the pilot or the trainee if the board finds that the refusal was without merit or there was no reasonable cause to refuse the assignment. In October of last year, the board adopted new policies for rest breaks for pilots. This bill amends the statutes to conform to the board's new policy. Under the bill, pilots must have a mandatory rest period of at least 10 hours with an opportunity for 8 hours of uninterrupted sleep after completing an assignment. And this doesn't exclude multiple assignments within a harbor area as long as the combined total duration of assignment time does not exceed 13 hours. Pilots must have a mandatory rest period that mitigates fatigue caused by circadian misalignment after 3 consecutive night assignments as defined by the board. The provision authorizing the board to impose sanctions for pilots or pilot trainees refusing an assignment is removed. A pilot trainee must not take a training program trip if the pilot trainee is physically or mentally fatigued, or if the pilot trainee has reasonable belief that the training program trip cannot be carried out in a competent and safe manner. I'd be happy to answer any questions.
Thank you very much. Any questions for staff? Representative Chapman.
Thank you, Mr. Chair, members of the committee. Appreciate you hearing this bill. I think staff did a great job, and I don't have much to add other than it makes sense that the individuals in this line of work would have adequate rest in between their jobs or their pilotage duties, and certainly the 7-hour rest break seemed a little low. 10-hour rest break with a minimum of 8 hours of sleep, with the liability, the technical, the stressful working conditions they have. I can only imagine if you were fatigued how much more difficult that job would be. So thank you for hearing the bill.
Any questions for the prime sponsor? Hearing none, I'll call forward Jamie Beaver and Eric von Brandenfels.
Thank you, Chair Sells and members of the committee. For the record, my name is Jamie Bever. I'm the Executive Director of the Washington State Board of Pilotage Commissioners. We're here to seek your support in modernizing our mandatory rest period statute to be more in line with current sleep science, taking into account natural circadian rhythms. The board is responsible for regulation, training, and licensing of maritime pilots in Washington's 2 pilotage districts, Puget Sound and Grays Harbor. Our mission is to provide safe, efficient, and competent compulsory pilotage. Our pilots guide massive tankers, cargo ships, cruise ships, and car carriers, just to name a few, in and out of the busy and intricate waterways of Puget Sound and Grays Harbor. Fatigue mitigation is paramount to the board's mission of safety. Recently, we enlisted the help of a prominent sleep expert to review our statutes and rules and the rules of the pilots. And then the board convened a committee of pilots, shippers, board members, and a physician to analyze those recommendations. Based on the feedback received from the committee, the board is requesting that the existing 7 hours of mandatory rest between assignments be changed to 10 hours with an opportunity for 8 hours of sleep, allowing some time on either end of that for falling asleep and then waking up refreshed to be able to pilot a vessel. At least 10 hours of rest between assignments is consistent with the normal and customary sleep intervals in other transportation professions and safety-sensitive industries. Thank you very much. I'm happy to answer any questions.
Okay. Mr. von Brandenfels.
Greetings. Thank you, Chair Sells and members of the committee. I am, for the record, Captain Eric von Brandenfels, President of Puget Sound Pilots. Thank you for the opportunity to advocate for House Bill 1647. It's brought to you by the agency legislation for the Board of Pilotage Commission. As a ship pilot myself and President of Puget Sound Pilots, I represent the pilots whose job it is to mitigate the threat that the large ships that transit the waters of Puget Sound pose to mitigate the threats they pose to the environment and the infrastructure of the port, as well as the citizens of the state of Washington, their property and their shorelines. The area we navigate in is approximately 7,000 square miles, and we operate a 24/7 year-round basis. We're very proud of our excellent safety record. We've had no major accidents in over 30 years, and the captain of the port has recently called this port the safest one in the country. We're very proud of that. Fatigue is increasingly recognized as a hazard that must be managed by pilots, the transportation industry, and regulators. The reduced sleep quality and quantity that experienced by ship pilots who often work at night and in conjunction with circadian misalignment can lead to an operationally significant level of cognitive impairment. Fatigue can have a detrimental impact on cognitive functions that are critical to safe maritime piloting, such as vigilance, judgment, reaction time, communication, situational awareness. Due to the fatigue-regulated incident in 2010 in Port Arthur, Texas, the National Transportation Safety Board placed an emphasis on marine pilotage fatigue. Born out of that concern, fatigue experts were brought into the entities around the country and came up with some findings.
Can I ask you to summarize, please?
The board, the commission found those findings with their committee, and we bring the 7 to 10 hours before you, and we support it. We think the long and short-term health benefits are great for pilots and for the safety of the environment in the people of the state of Washington. Thank you.
Thank you very much. Are there any questions? Hearing none, that closes the hearing on House Bill 1647, and we'll move into executive session on House Bill 1155 and House Bill 1490. We're back from caucus. We'll move into executive session, and we'll start with House Bill 1155 concerning meal and rest breaks and mandatory overtime for certain healthcare employees. Mr. Vice Chair.
Thank you, Mr. Chair. Thank you, Mr. Chair. I move that House Bill 1155 be reported out of committee with a due pass recommendation.
It's been moved and seconded. Any discussion, Mr. Vice Chair?
Thank you, Mr. Chair. This is a bill that we've dealt with and passed before. Support the underlying policy. Just would, for the record, would also just put on the record that I'm still concerned with some of the funding models for rural hospitals, and we'll be trying to work with maybe a chair of appropriations and the healthcare committee to make sure that our rural hospitals are taken care of with their funding models, but certainly support the policy and recommend adoption.
Representative Musbacher.
Thank you, Mr. Chair. And you'll see mixed on our sides. This bill is very difficult for me. I really appreciate your comments regarding rural hospitals because, again, I still feel like the bill needs a lot of work. I also realize that when you're dealing with life or death and you don't get a break and you're working overtime shifts, that I think it's different than if you're, answering the phone at a front desk at a hotel. So for me personally, this is a bill I think is important because they have so much responsibility, and it's important that we take care of our nurses.
Thank you very much. With that, the clerk will call Representative Hoff. I'm sorry.
Thank you, Mr. Chairman. This one's a tough one for me. The fact that our nurses are fatigued is critical in nature, and we need to address it somehow. What I struggle with is the supply or the employment shortage, and then if we pass this, what's the ultimate conclusion of that shortage? I think it has conflicting kind of objectives. So I'm going to have to vote no on this bill.
Thank you very much. Any further discussion? Hearing none, clerk will call the roll.
Sells?
Aye.
Chapman?
Aye.
Mossberger? Aye. Chandler?
No.
Gregerson? Aye. Off?
No.
Orsby?
Aye.
Clerk will give the tally.
5 ayes, 2 nays.
By your action on a 5-2 vote, you've passed House Bill 1155 out of committee with a due pass recommendation. House Bill 1490, Mr. Vice Chair.
Thank you, Mr. Chair. I move that House Bill 1490 be reported out of committee with a due pass recommendation.
It's been moved and seconded. Representative Ormsby.
Thank you, Mr. Chair. Asking for your support. This addresses an unintended consequence from a bill that we passed last year, providing presumptive
relief.
Presumptive coverage for folks suffering certain cancers at Hanford that would be on the federal worker industrial compensation plan, but for the fact that they didn't have qualifying medical exam, which wasn't required and wasn't given by the employer, and this would cover them as well. Good policy. I think we should pass it. Thank you.
Thank you. Representative Chandler.
Thank you, Mr. Chair, and I think that the committee should reject this bill at this time because it's, this is clearly a liability created by the federal government and under its direction, and I think it's unclear that we may be assuming what is really a federal responsibility, and I think that needs to be clarified before the bill moves forward.
Thank you very much. Any further discussion? Hearing none, the clerk will call the roll.
Sells?
Aye.
Chapman?
Aye.
Mossberger?
Aye.
Chandler?
No.
Gregerson? Aye. Off?
Aye.
Omsby?
Aye.
Clerk will give the tally.
6 ayes, 1 nay, 0 absent or excused.
By your action on a 6-1 vote, you've passed House Bill 1490 out of committee with a due pass recommendation, and we are adjourned for the day. Thank you. Thanks for coming.